phone. You're making these assertions without having personal experience.
I'm done.
He
done.
If you want to file a tool for defense.
If you want to file, Mr. Tinsley, you're done. You're done. You are done.
Welcome back to Myth and Reality, where real courtroom drama unfolds in real time. Today, we've got two cases that pack plenty of tension. First up, Aaron Salazar, charged with operating while intoxicated, but striking a plea deal that could dismiss the more serious super drunk charge. That's no small break, considering the fines, points, and possible jail time at stake. But even with this deal, the hearing doesn't exactly go smoothly. Misunderstandings, mistests, and even a little back and forth with the judge turn this into more than just a routine plea. And just when you think it's over, another case takes center stage. Carl Tinsley, a defendant locked in a heated conflict with his own attorney. It's raw, it's dramatic, and it's exactly the kind of legal clash that makes you wonder, who's really telling the truth? Stick around, because these cases raise tough questions about responsibility, trust, and how much patience judges really have.
Court calls the case, People versus Aaron Salazar.
People.
Morning, Your Honor. David Chan on behalf of Aaron Salazar. We do, Your Honor, we do have a plea in this matter in return for the super drunk charge being dismissed. My client will plead to OWI first.
That's correct, Your Honor. The 93-day misdemeanor, $100 to $500 fine, 6 points from his license, and various other Secretary of State sanctions, contrary to 257-6251A. We'll dismiss the OWI high VAC. There had recently been not a violation, but a progress report cautioning the defendant to remain compliant with his sober-link device. Mr. Shan had shared with me some of the explanation as to why there was that late/miss test. So I'm satisfied with that explanation and ready to move forward with this plea should the court accept it.
All right. And that's a correct statement of the plea.
Yes, it is, Your Honor.
Right,
he cleans residential houses and he takes SoberLink with him, and he left it at a residential house that he cleaned and then had to go back and get the owner to get the SoberLink out of the residential house so he could do the testing. So that is what happened.
May I have you sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Aaron Salazar.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days of jail, a $500 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes, I.
And to that charge, how do you plead?
Guilty.
Yes, I'm guilty.
You pleading guilty?
Guilty. Yeah.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
No trial.
No trial.
That's the stuff that we went through. Yeah.
You understand that you will not have a trial, sir?
I'm sorry, Ross.
Do you understand there'll be no trial?
Oh, yeah.
All right. You signed an advice of rights form today, is that correct?
Mm-hmm. Yes, sir.
All right. Do you have any questions regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form.
You understand these?
Yeah, I understand.
All right. You understand you're giving up those rights.
Yeah, you're waiving those. You're giving them up.
Yeah.
Okay. Is he understanding me?
Yes,
Because I've got to make sure that he does.
Yes, he does, and that's why I'm slowing down because you speak really quickly, and he does.
So that's the second insult Shan has given my court today. The first one when I wasn't out here, but was reported to me.
I did that.
No, that is
not
said it, and I know you said it. Now you just did that. Now, that first one was about how hard I think I work my staff.
It was an honest,
and then this was just a direct attack on me. All right, so no, I won't hold that against you. All right, but is he understanding?
Yes, he is.
All right. So you understand you're not gonna have a trial, you're waiving all of the rights that are on this form.
I understand.
All right. You understand that you're giving up your right to appeal of right.
Yeah, I understand.
All right. Are you on probation or parole?
Yeah, I understand.
That's beyond bond.
Okay.
Yeah.
Are you under the jurisdiction of any other court?
No,
All right. Have you ever been to prison for longer than a year?
okay.
Have you ever been to prison?
Yeah,
Have you been to prison
the present where?
in the United States? Have you ever been to prison? Not jail, prison.
Yeah.
Okay. Counsel approach, please. To reflect that it had a bench conference with counsel. I'm going to stop the plea at this time. I'm going to adjourn this matter out June 4th, 2025, 9 a.m. And we'll take care of submission. All right.
Thank you, Your Honor.
Thank you.
Here's where things get tense. The judge is trying to confirm that Salazar fully understands the consequences of his guilty plea: no trial, waived rights, serious penalties. But notice the hesitation, the short answers, the slight confusion. Judges must ensure that a defendant knowingly and voluntarily gives up their rights. Otherwise, the plea can be challenged later. That's why the judge slows down, even pointing out that Salazar's lawyer accused him of speaking too quickly. That moment sparks friction. Did the defense just insult the judge, or was it a genuine concern for the client's comprehension? This is where the courtroom balance shifts. The law requires clarity, but personal egos and tone can quickly turn up the heat. What do you think? Was the defense protecting Salazar, or taking a jab at the bench?
Bond group.
Next case on the docket.
Court calls case People versus Carl Tinsley.
People,
Is that what Johnson was here on?
yes.
Is that, you gotta watch, Alan, did you see him sitting over there in the corner? He was hiding. He comes in here and hides. Go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Carl Tinsley, who's approaching from custody.
They're ringing. Your name, sir?
Carl Tinsley.
Thank you. Just step over. Yeah, there you go. All right. Okay, what are we doing?
Your Honor, we ask this matter be set for jury trial.
All right. Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person.
Your Honor,
I'm sorry. I'd like to speak.
Oh, okay, hold on. Yeah, counsel first.
I have jury selection Lawrence Buckner in the Ypsilanti District Court on June 9th.
Jury selection
Yes, Your Honor.
before Judge Barr.
Yes, Your Honor.
It'll be here.
Okay,
We all select on the same day.
all right.
So.
Your Honor, if I may, so Mr. Johnson and I have a fundamental difference in defense strategy. There's no point in us moving forward together on this case. Mr. Johnson is representing me in circuit court. I've submitted a motion to have Mr. Johnson remove his counsel in that case. Excuse me?
Why?
Why? Because Mr. Johnson is totally uninterested in this case, in that case, in this case
Okay.
as well.
Mr. Tinsley, you've been before me before, and I'm just gonna tell you this.
Okay.
I haven't known Mr. Johnson.
This is one of the most dramatic points of the hearing. Tinsley openly tells the court he doesn't trust his lawyer, Kareem Johnson, accusing him of being uninterested and unresponsive. For a defendant, claiming your own attorney isn't fighting for you is a bold and risky move, especially in front of the judge. Remember, defendants are entitled to effective counsel, but not necessarily a perfect or friendly relationship. Judges hear these complaints all the time, and they usually boil down to frustration or miscommunication. But here's the twist. Johnson is actually representing Tinsley in 2 cases at once, which makes this breakdown of trust even more explosive. Do you think Tinsley had a point, or was he sabotaging his own defense by burning bridges in
Necessarily all
open
that
court?
long.
Okay.
But I'm gonna tell you, for maybe about the past year plus that he's been appearing before this court, there has not been a client that he has walked into this court where he has not been interested in their case and zealously representing his defendant. And so I don't believe you. You coming before telling me that about this attorney, I don't believe it for 1 minute, not 1 minute. I think, because you've been before, is that you're probably not listening to him. He is advising you. I can guarantee he's protecting every right you have.
And you'd be absolutely
to the
wrong.
fullest.
I have not seen, this gentleman has told me he's going to show up to see me countless times at the county jail. He has not. I've been waiting over 2 years.
Notice how firmly the judge steps in here. Instead of questioning Johnson's performance, the judge openly defends him, saying he's never seen this attorney fail to zealously represent a client. That's significant. Judges don't usually vouch for lawyers unless they've seen a consistent track record. To the judge, this looks less like poor lawyering and more like a client who doesn't want to listen. And when Johnson responds, clarifying he's only been on the case since April, it undercuts Tinsley's 2 years of neglect claim. This is a powerful reminder of how credibility is everything in court. If a judge doesn't believe you, your leverage evaporates. Here, the judge makes it crystal clear. Johnson stays on the case, whether Tinsley likes it or not.
For
what?
for discovery in another case at all. This gentleman doesn't answer his phone. You're making these assertions without having personal experience.
I'm done.
He
Done. If
is
you want to file,
a tool
if you
for
want to,
defense.
if you want to file, if you want to file, out, Mr. Tinsley, you're done. You're done. You are done.
Yeah, I think I need to respond to the 2-year comment. Mr. Tinsley does have a matter that's been pending for 2 years. I'm the 4th attorney on that matter. I have only been representing him since April. When I go to speak to him, he doesn't want to talk about what I want to talk about, Giannis. I just want to clear that up for the record.
And Mr. Johnson, I meant my words sincerely. I've dealt with Mr. Tinsley before. This is a game we play. So I'm done.
All right.
You're still on this case, regrettably, but
2 cases, 2 very different lessons. For Salazar, a plea deal meant avoiding a harsher charge, but his confused answers showed just how crucial it is for defendants to understand exactly what they're giving up in court. For Tinsley, the drama wasn't about charges at all, but about trust between a defendant and his attorney. The judge made his stance clear. In this courtroom, credibility and professionalism win over frustration and finger-pointing. So what do you think? Was Tinsley justified in calling out his lawyer, or did the judge get it right by backing the attorney? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here on Myth and Reality.